My name is Renata Cole. I am 36 years old, and I am an estate planning attorney licensed in the state of Connecticut. I draft wills, trusts, and powers of attorney for a living. I have sat across from dying people more times than I can count, and I have seen every version of what happens when a family smells money on a deathbed. The daughter who suddenly starts visiting, the son-in-law who offers to help with the paperwork, the cousin who brings flowers and a notary in the same week. But I never thought I would become the case study. On March 14, 2023, at 6:47 p.m., I was sitting in a molded plastic chair in the third-floor waiting area of Hartford Memorial Hospital, holding a cup of coffee I had not taken a single sip from. The cup was lukewarm. The waiting room smelled like floor cleaner and stale air conditioning. My mother, Dolores Cole, was in room 312, 41 feet away, separated from me by a hallway, a nurse's station, and a closed door I had been asked to stay behind. My sister, Vivian Cole Patterson, was inside that room. She had arrived 22 minutes earlier with a man I did not recognize carrying a leather briefcase. A brown briefcase with brass clasps. I noticed the clasps because they caught the fluorescent light as he walked past me without making eye contact. The nurse at the desk, a woman named Kathy Armando, had looked at me with something between pity and discomfort when Vivian said the words that would become the fulcrum of everything that followed. She just needs some private time with Mom. Family stuff. I was family. I had been family every Tuesday and Thursday evening for the past 4 months, sitting beside my mother's bed reading to her from the mystery novels she loved, adjusting her pillows, arguing with the billing department about a $3,400 charge for an imaging scan that had been ordered twice by mistake. But I stayed in the chair. I stayed because our mother had stage 4 pancreatic cancer, because she had been given 11 days to 6 weeks, and because I told myself that fighting in a hospital hallway was beneath the woman I had worked to become. That was my mistake. Not the sitting, the silence. 43 minutes later, Vivian walked out with the briefcase man behind her. She smiled at me, not warm, not cold, just efficient, and said, "She's sleeping now. You should come back in the morning." She touched my shoulder as she passed. The briefcase man was already at the elevator. I went inside anyway. My mother's eyes were half open, her breathing shallow, her left hand resting at an angle that told me someone had recently moved it. On the rolling tray beside her bed, there was a single sheet of paper turned face down. I did not touch it. I photographed it. Then I photographed the tray, the room, the clock on the wall that read 7:14 p.m., and the medication pump display next to her IV line. I already knew. Not the specifics, but the architecture. I had seen it 100 times in my office, in the trembling hands of other people's mothers, other people's sisters, other people's greed. I knew the playbook because I had spent 11 years watching families execute it. If you are watching this right now, tell me where you are. Tell me what time it is for you. Because I need you to understand that while you sit there, right now, someone in a hospital room somewhere is being talked into signing something they do not fully understand, by the person they trust the most. And somewhere outside that room, there is a woman sitting in a plastic chair who will not know what happened until it is almost too late. Part 2. The history. My mother was not a wealthy woman by most definitions. She was a retired municipal clerk from Glastonbury, Connecticut, who had worked for the town for 31 years. She processed permits, filed records, and answered the same questions about property taxes every spring, with a patience I never fully appreciated until I was old enough to understand what patience actually costs. She lived in a 3-bedroom colonial on Hebron Avenue that she and my father bought in 1987 for $142,000. By 2023, the property was appraised at $615,000. She had a pension, a small 401k, that had grown to roughly $210,000, a life insurance policy worth $150,000, and a savings account with $47,000 in it. Not a fortune, but enough to change behavior. Enough to make someone drive from Scottsdale to Glastonbury 3 times in 6 weeks. My father, Gerald Cole, died in 2016 of a heart attack at age 64. He collapsed in the garage while changing the oil in his truck, a 2004 Ford F-150 he had owned for 12 years and refused to replace. He left everything to my mother with a standard spousal transfer, No complications, no drama. When he passed, Vivian flew in from Scottsdale, stayed 3 days, and flew back. She attended the funeral. She did not attend the burial. She said she had a flight. I handled the probate. I handled the house insurance switchover. I handled the utility bills and the pension survivor benefit paperwork and the 18 phone calls it took to close his Verizon account. I cleaned out his closet. I donated his clothes to the VFW thrift store on New London Turnpike. I found a birthday card for my mother in his nightstand drawer, unsigned, dated 2 weeks before he died. I gave it to her. She read it once and put it in the spiral notebook she kept by the kitchen phone. That was fine. That was my role. Renata handles things. Vivian is 3 years older than me. She was the one who left. I was the one who stayed. That is not resentment. It is geography. She married Douglas Patterson in 2011, a commercial real estate agent who sold strip malls in the Phoenix suburbs, and drove a leased BMW that he parked in the driveway as if it were a monument. By 2020, Douglas had lost his license in Arizona after a complaint involving misrepresented square footage on a retail property in Tempe. The complaint was filed by a dentist who had signed a lease for 2,100 square feet and received 1,740. Vivian never told our mother about the license. She told her Douglas was transitioning to consulting. My mother believed it because my mother believed her daughters. Between 2020 and 2023, Vivian called our mother an average of once every 2 weeks. I know this because my mother kept that spiral notebook by her kitchen phone, a habit from another era, and she logged every call. Date, time, duration, what they talked about. Some entries were detailed. Vivian called 3:15 p.m., 22 minutes, talked about the dogs and Douglas's new project. Others were sparse. Called. Short. I found that notebook in April 2023, and it confirmed what I had suspected for years. Vivian's calls increased in frequency the moment our mother's diagnosis went from possible mass to confirmed malignancy. In January 2023, Vivian called once. In February, she called 4 times. In the first 2 weeks of March, after the oncologist told us treatment would be palliative only, Vivian called 9 times. 9 calls in 14 days, from a woman who had averaged 2 a month for 3 years. She also started visiting. Not to help, not to sit, to position. The first visit was February 19th. Vivian came alone, stayed overnight at the house, and told my mother she had been doing a lot of thinking about the family. She cooked dinner, something she had not done in that kitchen since 2009. I was not invited. When I called my mother the next morning, she sounded tired but said, "Vivian is worried about you, honey. She thinks you work too much." That sentence should have been a warning. It was Vivian's signature move, expressing concern for me as a way of isolating me. She was not worried about me. She was narrating a version of me to our mother that would make the next steps easier. A version in which I was stressed, overworked, maybe not thinking clearly. A version in which removing me from responsibility would be framed as kindness. The second visit was March 3rd. Vivian brought Douglas. They took my mother to brunch at a place on Main Street, a cafe called the Lemon Tree that my mother had never been to before. My mother mentioned it casually the next day. Douglas said he knows a wonderful attorney in Hartford who does elder work. I asked which attorney. My mother said she couldn't remember the name. That was the moment my chest went cold. I am an estate attorney. My mother already had a will, one I had drafted myself in 2018, reviewed with her line by line, notarized in my office with 2 independent witnesses, and filed with the Glastonbury Probate Court. A will that split her estate equally between her 2 daughters, named me as executor, and established a modest trust for any future grandchildren. There was no reason for another attorney, unless someone needed a different outcome. I said nothing. I did not confront Vivian. I did not interrogate my mother. Instead, I did what I have been trained to do. I started documenting. Not because I was angry, because I had seen this exact pattern: the increased contact, the isolation of the competent sibling, the flattery, the meals out, the introduction of an outside attorney, in at least a dozen cases that had come across my desk in the previous 5 years. I could have written the next 3 chapters of this story from memory. The only difference was that now, the protagonist was me. I opened a file on my laptop that night. I named it DC Mom 2023. DC for Dolores Cole. I treated it like a case. Because it was one. Part 3. The breaking point. On March 10th, 4 days before the hospital visit, I received a text from Vivian at 9:23 a.m. It read, "Hey Ren, I think we should talk about Mom's wishes while she's still lucid. I don't want to make this harder later." The language was careful. Mom's wishes. While she's still lucid. That word, lucid, was doing specific legal work, whether Vivian knew it or not. In Connecticut probate law, testamentary capacity requires that the person understand the nature and extent of their property, the natural objects of their bounty, and the disposition they are making. Lucid is the word that opposing counsel uses to argue that a document signed on a hospital bed is valid. Vivian was building a narrative of competence. She was prepping the ground so that if anyone questioned what came next, she could point to this message and say, "We discussed it. We agreed. Mom was aware." I responded, "Happy to talk. When?" She called me that evening. The conversation lasted 14 minutes. I recorded it. Connecticut is a one-party consent state under Section 52-57DD. I verified this before I pressed the button, even though I already knew. Even in my own crisis, I followed procedure. The recorder was an app on my phone called Tape-A-Call. I had recommended it to clients for 3 years. Vivian told me that Mom had been expressing concerns about the existing will, that she felt uncomfortable with me being both a beneficiary and the executor, that she wanted someone neutral to review the documents. I let her finish. Then I asked one question. Who raised this concern? Mom or you? There was a pause. 4 seconds. I counted. Then Vivian said, "Does it matter? She's dying, Renata. This isn't about you." That sentence. This isn't about you. She had used it my entire life. When I graduated law school at the top of my class and she didn't attend. It isn't about you, Ren. I had a conflict. When I asked why she hadn't contributed to Dad's funeral costs, a funeral that cost $11,400, all of which I paid. This isn't about money, Renata. When I told her I was hurt that she missed Mom's 70th birthday, not everything is about you. It was her kill switch. The phrase she deployed whenever accountability got too close. It reframed every legitimate question as selfishness. It made the person asking the question into the problem. But this time, something in me did not fold. Something settled. Not rage. Not sadness. Precision. The same feeling I get when a case file clicks into focus and I can see the entire timeline on one page. I said, "Vivian, I want you to know that whatever Mom decides is her right. I will never contest her autonomy. But I will be requesting copies of any documents she signs, and I will be reviewing them in my professional capacity. That is also my right." The line went quiet. Then she said, "You're making this into a legal thing." "It became a legal thing," I said, "the moment you brought an attorney to brunch." She hung up. I saved the recording. I timestamped it. I exported it to 2 locations, my laptop and a USB drive I keep in my office safe. I added it to the file. What I did not know yet, what I would not learn for another 6 days, was that the man with the leather briefcase on March 14th was named Arthur Beckwith. He was not a licensed attorney. He was a notary public and paralegal, operating out of a strip mall office on Franklin Avenue in Hartford, Suite 4B, between a nail salon and a tax preparation service. His notary commission had been renewed in 2021. He had no Martindale-Hubbell listing, no State Bar Association membership, no professional liability insurance that I could find. And the document my mother signed in room 312, the one I photographed face down on her tray, was a holographic codicil to her will, drafted on plain paper, witnessed by Vivian and notarized by Beckwith, that replaced me as executor with Vivian, reduced my inheritance to a fixed sum of $25,000, and transferred the Hebron Avenue property, the house our parents bought the year I was born, entirely to Vivian Cole Patterson. Before I tell you what I did next, I need you to understand something. I was not angry about the money. $25,000 or $500,000, the number was not the wound. The wound was that my mother was dying, her body full of tumors and opioids, and my sister turned her hospital room into a closing table. The wound was that I was 41 feet away, holding a cup of coffee I never drank, trusting that family stuff meant something sacred. It did not. It meant paperwork. Part 4. The documentation. I did not confront Vivian. I did not call a family meeting. I did not cry in my car in the parking garage, although I sat there for 9 minutes before I turned the key. I drove to my office. It was 8:40 p.m. on a Tuesday. I unlocked the door, turned on the desk lamp, the green glass banker's lamp my father gave me when I passed the bar, and opened a new subfolder inside DC Mom 2023, labeled Codicil Challenge, Evidence. Here is what I did over the next 72 hours. I am going to tell you every step because I want you to understand that justice is not a feeling. It is a filing system. First, I called Hartford Memorial Hospital's Patient Records Department the following morning at 8:02 a.m., 2 minutes after they opened. I requested, under HIPAA's personal representative provisions and my existing healthcare power of attorney for my mother, her complete visitor log for room 312 on March 14th. The log was emailed to me by 11:30 a.m. It confirmed 3 visitors between 6 o'clock and 7:30 p.m. Vivian Cole Patterson, arrival 6:25 p.m. Arthur Beckwith, arrival 6:26 p.m. And Renata Cole, arrival 7:12 p.m. 1 minute between Vivian and Beckwith. They arrived together. My arrival was logged 25 minutes after Vivian's exit at 6:47. The gap was documented. I printed it. I highlighted it. I filed it. Second, I requested the nursing notes for my mother's care between 5 p.m. and 8 p.m. that day. The notes, written by Kathy Armando, RN, included the following entry at 6:18 p.m. Patient received 2 milligrams dilaudid IV push per Dr. Navarro standing order. Patient drowsy but responsive. Vitals stable. Dilaudid. Hydromorphone. A Schedule II opioid analgesic, roughly 5 to 7 times more potent than morphine. Administered 9 minutes before Vivian and Beckwith entered the room. My mother signed a legal document altering the disposition of her entire estate while under the active influence of intravenous narcotics. That single nursing note, 12 words in a chart entry that Kathy Armando probably wrote in 30 seconds, would become the cornerstone of everything that followed. Third, I ran a background search on Arthur Beckwith. He held an active notary commission in Connecticut, renewed April 2021. He did not hold a law license in any state. I checked Connecticut, New York, Massachusetts, and Arizona. The last one because Douglas had connections there. His office address on Franklin Avenue was a shared workspace above a dry cleaner. His website, a single-page Wix site with a stock photo of a handshake, listed his services as document preparation, notary services, and legal form assistance. His online reviews, 4 of them, all posted within a 6-month window between September 2022 and February 2023, described him as affordable and quick with paperwork. I printed every page. I saved screenshots with metadata timestamps. I archived the website using the Wayback Machine submission tool in case he took it down. Fourth, I contacted my colleague, Margaret Chen. Margaret is a probate litigation attorney at Roswell and Stein in New Haven, one of the most respected estate dispute firms in the state. We had met at a Connecticut Bar Association continuing education seminar in 2019. She had presented on undue influence doctrine. I remembered her because she had opened her presentation with a sentence I wrote down. The person who rewrites the will is almost never the person who visited the most, until the diagnosis. I trusted her judgment and, more importantly, her discretion. I told her what I had. She listened without interrupting for 11 minutes. Then she said 5 words I will never forget. Renata, you already have enough. But I was not done. Because I am not the kind of woman who builds a case with enough. I build cases that leave no door open. I build cases that make the other side's attorney advise settlement in the parking lot before the hearing starts. Fifth, I filed a formal notice with the Glastonbury Probate Court, alerting them that a codicil to the will of Dolores Cole may exist and had not yet been submitted. Under Connecticut General Statutes Section 45A-251, any interested party may request notification of filings involving a decedent's estate. The clerk, a woman named Patricia Holt who had worked in that office for 19 years, noted my request and told me, off the record, that she had seen this kind of thing before, more than people think. Sixth, and this was the detail that Vivian never anticipated, the one that made Margaret's paralegal whistle through her teeth when she read the evidence summary. I filed a preservation request for the hospital's security camera footage. Hartford Memorial retained hallway surveillance footage for 90 days. I filed the request through Margaret's office on March 17th, 3 days after the signing, well within the window. The footage from the third-floor hallway outside room 312 showed Vivian entering at 6:25 p.m., with Beckwith one step behind her. It showed Beckwith carrying the brown briefcase in and carrying it out 41 minutes later. It showed Vivian pausing at the nurse's station on her way out, leaning over the counter, and saying something to Kathy Armando while looking in the direction of the waiting area, the direction of me, still sitting in the plastic chair, still holding the cold coffee, still believing that my sister was capable of grief without an agenda. I sat back in my office chair at 11:47 p.m. on March 17, 2023, and looked at the file spread across my desk. Visitor logs, nursing notes with medication timestamps, a notary public's credentials and unlicensed practice record, security footage preservation confirmation, a recorded phone call on a USB drive, a call log notebook in my mother's handwriting, a photograph of a face-down document on a hospital tray. Vivian thought she had 43 minutes of privacy. She thought that asking me to wait outside was enough. She thought the woman in the plastic chair was the same woman who had always folded, who had always absorbed the cost, filed the paperwork, and never asked why she was the only one carrying anything. If you have ever been that person in your family, the one who handles everything and receives nothing but the assumption that you always will, then you know exactly what I mean. They mistake your reliability for weakness. They confuse your patience with consent. And the day you stop consenting, they will act like you started a war. But you did not start it. You just stopped losing it quietly. Part 5. The Consequence. My mother, Dolores Cole, passed away on April 2, 2023, at 4:17 a.m. She was 71 years old. I was holding her hand. Her fingers were cool and dry, and the room was quiet except for the hum of the oxygen concentrator that was no longer doing anything. The nurse turned it off at 4:22. I stayed until 5:15. I kissed her forehead. I signed the discharge paperwork. I drove home in the dark. Vivian was in Scottsdale. She had flown back on March 26th. She said she would return when things got closer. Things got closer 7 days later, and she was 2 time zones away. The funeral was held on April 6th at St. Augustine's in Glastonbury. The church was 3/4 full. My mother had lived in that town for 36 years, and people remembered her. Vivian flew in the morning of the service, wearing a black dress I recognized from our father's funeral 7 years earlier. She hugged me at the door of the church. I let her. Her perfume was the same, something floral and expensive that she had worn since her 20s. There is a time for confrontation and a time for stillness. That was stillness. I would not dishonor my mother's service with what was coming. 11 days later, on April 17th, Vivian submitted the codicil to the Glastonbury probate court. She filed it with a cover letter, typed, not handwritten, stating that the document reflected our mother's final and clearly expressed wishes, made while she was alert and of sound mind. Patricia Holt, the clerk, flagged it immediately per my earlier request and called Margaret Chen's office within the hour. Margaret called me at 2:14 p.m. She said, "It's filed. We're ready." On April 24th, Margaret filed a formal objection to the codicil on my behalf, along with a petition to invalidate under Connecticut General Statutes, Sections 45A-250 and 45A-257. The filing was 23 pages. The grounds were threefold. First, lack of testamentary capacity. The nursing records confirmed that Dolores Cole was administered 2 milligrams of intravenous Dilaudid at 6:18 p.m., 9 minutes before Vivian and Beckwith entered the room at 6:25. Dr. Navarro, her attending oncologist, provided a written declaration confirming that a patient receiving IV hydromorphone at that dosage would experience impaired cognition, diminished executive function, reduced judgment, and potential confusion, conditions fundamentally incompatible with the legal standard for executing a testamentary instrument in the state of Connecticut. He wrote, "It is my medical opinion that Mrs. Cole would not have possessed the cognitive clarity required to understand the nature and consequences of a legal document at the time in question. Second, Undue influence. The visitor logs, the call frequency data from the spiral notebook, the recorded phone call of March 10th, the security footage, and the pattern of escalating contact collectively established a campaign of isolation, persuasion, and manipulation consistent with undue influence, as defined under Connecticut case law. Specifically, the factors outlined in Lockwood v. Lockwood, a confidential relationship, a substantial benefit to the influencer, the participation of the influencer in the preparation of the instrument, and the testator's weakened condition. Vivian met all four. Third, procedural deficiency and unauthorized practice. Arthur Beckwith, the notary, was not a licensed attorney. Under Connecticut General Statutes Section 51-88, a notary public may witness and authenticate signatures, but may not draft, prepare, or advise on testamentary documents. The codicil's language, including specific executor replacement provisions, fixed sum bequests, and real property transfer clauses, exceeded the scope of notarial service by a considerable margin. Beckwith had, in effect, practiced law without a license, and Vivian had hired him to do it. The probate judge, the Honorable David Marchetti, scheduled a hearing for June 12. Vivian retained an attorney out of Hartford, a man named Craig Salter from a mid-tier firm called Salter, McBride & Wynn, that primarily handled insurance defense litigation, not probate. He filed a response arguing that the codicil represented Dolores Cole's genuine and uncoerced intent, and that my challenge was motivated by professional ego and financial self-interest. He used the phrase sibling rivalry twice in a 4-page filing. He cited no Connecticut probate case law. Margaret noticed. Margaret dismantled it in 9 pages. She attached 31 exhibits. The hearing lasted 2 hours and 14 minutes in Glastonbury Probate Court, a room I had appeared in dozens of times on behalf of other families. This time I sat at the petitioner's table. Vivian sat 12 feet to my left. She did not look at me once during the opening statements. Vivian testified first. She said our mother had been alert and aware, during the signing, that she had asked for this change herself, that the dilaudid didn't seem to affect her. Margaret stood, adjusted her glasses, a gesture I later learned she uses deliberately before her most effective questions, and projected the nursing note on a screen the judge had approved. 6:18 p.m., 2 milligrams dilaudid IV push, patient drowsy but responsive. She asked Vivian if she was aware her mother had received intravenous opioids 9 minutes before signing a legal document. Vivian said she was not. Margaret asked if Vivian had inquired about her mother's medication status before producing a document for signature. Vivian said she had not. Margaret then asked why Arthur Beckwith, a notary public with no legal training and no malpractice insurance, had been selected to facilitate the execution of a testamentary instrument. Vivian said Douglas had recommended him. Margaret asked if Douglas Patterson currently held a professional license in any state. Vivian's attorney objected. Judge Marchetti overruled. Douglas Patterson's revoked Arizona real estate license entered the record as Exhibit 14. The security footage was played on the screen. The spiral notebook was entered as Exhibit 7. The recorded phone call was entered as Exhibit 9. When my voice on the recording said, "It became a legal thing the moment you brought an attorney to brunch," the courtroom was quiet. Vivian looked at the table. She did not look up again for the rest of the proceeding. Judge Marchetti issued his ruling on June 26, 2023. He declared the codicil invalid on all 3 grounds. He further referred Arthur Beckwith to the Connecticut Statewide Grievance Committee for investigation into unauthorized practice of law. He restored the original 2018 will, the will I had drafted, the will my mother had signed with 2 independent witnesses in my office on a Tuesday afternoon in October, the will she had read aloud to make sure she understood every word, in its entirety, and in a passage of his written opinion that Margaret later printed, framed, and hung in her office next to her bar admission certificate, Judge Marchetti wrote, "The court finds that the decedent's testamentary autonomy was not exercised in this matter. It was exploited. The evidence before this court paints a portrait not of a mother freely changing her wishes, but of a vulnerable woman whose final days were commandeered by the very person she trusted to protect them." I did not celebrate. I read the opinion once in my car in the courthouse parking lot, closed my laptop, and drove to my mother's house on Hebron Avenue. I sat in the driveway for 20 minutes. The The porch light was still on a timer. It came on at 6:30, the way it always had. The way she had set it. The driveway was empty. The house was dark behind the windows. But that porch light came on, and for a moment, it felt like she was still in there, waiting for me to come inside. Part 6. The Reckoning. The estate was settled by September 2023. The Hebron Avenue house sold for $608,000, slightly under appraisal, which Margaret said was normal for probate sales in a cooling market. The proceeds, combined with the pension payout, the 401k distribution, the life insurance, and the savings account, were divided equally between Vivian and me, exactly as our mother had intended in the 2018 will, the will she signed with clear eyes, on a clear afternoon, in a room where no one was holding a briefcase, and no one had been given dilaudid 9 minutes earlier. My share came to approximately $517,000 before taxes, executor fees, and Margaret's legal costs. Vivian received the same amount, equal, the way our mother wanted it. I donated $25,000 of my share to the Connecticut Legal Aid Foundation's Elder Abuse Prevention Program. That number was not random. It was the amount the codicil would have left me. The sum Vivian decided my entire relationship with our mother was worth. I wanted that number to mean something different. I wanted it to protect someone else's mother. Arthur Beckwith's notary commission was suspended in August 2023, pending the outcome of the grievance committee investigation. His strip mall office on Franklin Avenue, Suite 4B, between the nail salon and the tax preparation service, closed the same month. The Wix website went offline. The 4 online reviews disappeared. I do not know what happened to him after that. I did not look. He was not the architect. He was the tool. Douglas and Vivian separated in November 2023. I learned this from a cousin at Thanksgiving. A detail shared over sweet potatoes as casually as a weather report. I felt nothing about it. That is not coldness. That is the specific emptiness that arrives when you realize the person who tried to take everything from you never had anything solid to begin with. Their foundation was made of leased BMWs and strip mall offices, and cover letters that used the phrase, sound mind, about a woman on intravenous opioids. Vivian and I have not spoken since the hearing. She sent me one text message, on July 3, 2023. It read, "I hope you're proud of yourself." I read it once. I did not respond. Not because I had nothing to say. Because I had already said everything that mattered, and I said it under oath, with documentation, in a courtroom where the truth had consequences. Anything I texted back would have been smaller than that. I still practice estate law. I still sit across from families who are afraid of what dying will do to the people they love. But now, when a client tells me they are worried about a specific child, a specific sibling, a specific spouse who has been visiting more often, or asking a lot of questions about the house, I listen differently. I ask different questions. Has anyone new suggested changing your documents recently? Has anyone asked you to sign something without your other children present? Do you feel comfortable telling me if someone asked you not to discuss this meeting with other family members? These questions did not come from a textbook. They did not come from a bar association seminar. They came from a plastic chair in a hospital waiting room, where I sat for 43 minutes, while my sister rewrote my mother's last wishes on a tray table, next to a morphine drip. I kept my mother's spiral notebook. It sits in the top drawer of my desk at home, next to a photograph of her from 1994, the year she started working for the town of Glastonbury. In the photo, she is wearing a navy blazer and a smile that looks like she knows something no one else in the room does. I think she did. I think she always knew that love and trust are not the same thing, that the people who love you most are sometimes the ones you have to protect your decisions from, and that a will is not just a piece of paper. It is the last sentence you will ever speak, and you deserve to speak it clearly, without someone else holding the pen. If you are the one they always counted on to stay quiet, the one who handled the paperwork, drove to the hospital, made the phone calls, absorbed the cost, and never once asked why you were the only one carrying anything, I want you to hear me clearly. Your silence is not peace, it is permission. And the moment you stop giving it, you will discover that the people who needed your silence the most are the ones who deserved it the least. What would you have done if your own sister used your mother's last days to rewrite the one document that was supposed to be sacred? Would you have stayed in the chair? Would you have challenged it in a courtroom, knowing it would mean never speaking to her again? Or would you have told yourself it wasn't worth the fight, the way I almost did, the way I sat there with that cold coffee, the way I walked into that room and saw the paper face down on the tray and felt something inside me go very, very still? This story is completely fictional and created for entertainment and reflection. Every name, location, legal proceeding, and institution in this narrative was invented for storytelling purposes. But if you recognized something in it, a waiting room you have sat in, a document you were not shown, a family member who moved faster than grief should allow, a sister or brother who suddenly started visiting after the diagnosis, then the feelings it raised are not fictional at all. They belong to you, and so does whatever you decide to do next.